Hello, once again. Um, I am going to be lecturing, and we are going to be discussing um, the um, unit, the last unit here. I think the previous video um, I discussed forms of business and choice of entity, and also there was a recording of my last online session. Also posted to that prior unit. We are now going to be discussing the next unit, which is agency and corporate governance. And in particular, most important to you as a manager or entrepreneur or possible member of the board of directors or CEO of an entity, an artificial entity, a corporation of some sort. And then we need to understand what duties, what level of performance, what is required of us by virtue of the fact that we are a manager, a member of the board of directors, an officer, key employee. And we need to particularly understand what is required of us when we accept those positions. Because what we will find out that if you're a manager who is also an agent, which generally means that you have the power to hire or fire and or enter into contracts with third parties that bind the corporation to that contract, then you're an agent. And that means that your principal, the corporation, your employer, you owe them what we call fiduciary duties. And these are it's no longer an arm's length relationship like it would be with, say, a line worker at a fast food restaurant, right? That's not an agent. And you owe specialized heightened duties to your employer. Yeah, and I'm hear some of you saying, yeah, so what's your point, Schoolie? The point is, and we need to understand this, and actually we'll get tied into Buffalo Creek, which I'll tie up on my next online session, which will be recorded and posted. But that in the event that you fail to fulfill one of these duties that is owed to your employer, and because of that failure, that breach of that duty, then your employer is damaged. And as a result of that damage, that loss because of your failure to perform your fiduciary duties, that they seek to recover those losses from guess who? You. Okay, and I think I've already kind of suggested to you previously that that's key to understand, that if you are a manager and you breach one of these duties, and that as a result your employer suffers a loss, then can you find yourself in the crosshairs of a lawsuit seeking to recover those damages? And the answer to that is yes. And you need to understand those circumstances and fully understand that in certain circumstances, this may be a corporation, or more, I think more likely, their insurance company is going to make an effort to get at your personal assets. And not only could you lose your job, and probably would in such a situation, but you could also find yourself having to either pay up or file bankruptcy to avoid the liability, which of course is a total and complete disaster. And so you need to understand that that You know, that's why they're paying you the big bucks. I'm being sarcastic, obviously. But that comes with the territory. And when you accept a voluntary position as an agent, even though it's it's part of your duties, then you owe certain heightened duties to your employer. Okay, and it's critical that you understand that. And so this idea, and actually this is we hearken back to this idea of if you owe a duty to another and you breach that duty, and as a result of the breach of that duty, that individual suffers a loss, guess what? You may be required by tort law, this is a tort concept, to compensate the person that suffered that loss. And essentially, we call that a negligence cause of action. If we hearken back to our delivery driver, when he diverts his attention from the roadway and hits the little old lady in the crosswalk, he has committed negligence. We all owe a duty to exercise ordinary care and caution when we are operating our motor vehicles. The delivery driver breached that when he diverted his attention away from the roadway to use his handheld. The little old lady was hit and struck. She suffered a loss. And we now know that she and her attorney can sue the driver, among others, for those losses. That's a negligence cause of action. Buffalo Creek is a mass tort negligence cause of action. Stern's allegations were that Buffalo Creek owed the residents, or Buffalo Creek Mining Company owed the residents of Buffalo Creek a duty, that they breached that duty, and ultimately Pittston too. And they breached that duty. And as a result, the residents of Buffalo Creek were injured, and they are now seeking to be compensated. And so one step further then, and taking this then into the business context, is that when you owe a fiduciary duty, a heightened duty to your employer because you're an agent, then essentially if the employer suffers a loss, can you be called to compensate your employer for that loss? Yes. And this is obviously is a very important concept to you personally to understand, that when you accept a position which essentially makes you an agent of your employer, then you need to be very aware that you must fulfill that agreement. And if you fail to, and your employer suffers a loss, then you're in a robot to be going danger, Will Robinson, danger, Will Robinson. And if you've seen my other videos, then you understand that reference. Okay. All right. Let's kind of now backtrack a little bit. I'm going to pull up the agency PowerPoint just to understand. Go back in that a little bit of detail, help you with some of the discussion questions associated with this unit. And so I am going to try to pull up, yeah, I think I can, my agency PowerPoint. Woohoo! I think you should be able to see that now. This slide here is simply defining what an agency relationship is, and it's generally a voluntary relationship. It's created by agreement between a principal and an agent. In our context, it's always what? The principal is the employer. Who's the agent? It's the manager that is the agent. And essentially, the manager, and go back to, again, to our fast food example, the manager of a store who is given the power to hire and fire, and we understand this already, I think we discussed this very early on, that manager is an agent, and he has the power to enter into contracts on behalf of, not necessarily himself as the manager, but on behalf of who? The principal, his employer. the corporation, the fast food corporation. And so he negotiates with a potential employee, offers that potential employee a job. If the potential employee says, yes, I accept, and shows up for work, then we know we have a contract, an employment contract, right? Yeah. And it was, and who are the parties to the contract? And generally it's going to be who? The employer, fast food restaurant, Inc., and the employee. Generally the manager, as long as he had authority to enter into that agreement, then generally is not going to be party to the contract. And what the significance of that is if, let's say the employee believes he has been stiffed on his wages and needs to sue or file a claim for those wages, then it's not going to be necessarily against the manager. Manager could perhaps be a witness, but the responsible paying party should be who? Yeah, it's Fast Food Inc. It's the employer of the employee, of the line worker. Okay, and there's some important concepts that if you have that, and you can also extend that then to other third parties. For instance, if you're an outside salesperson, and part of your duties is to call on potential customers of your employer and sell them things. And so, for instance, you go to a hospital, you're a hospital supply outside salesperson. They place an order, the hospital places an order with you for certain supplies. You take that order back. You accept it, actually. Initial it, give them a copy of the purchase order. You take it back to your employer, and there is a contract form, right? The outside salesman is the agent. Who are the parties to the contract? It's a hospital supply company and the hospital. And if there's a dispute over price or quality or quantity of the order, something goes wrong with it, it could end up in a breach of contract suit between who? Between the hospital and the supply company. And generally the outside salesman could be a witness, but probably would not be a party. Okay, so those two situations then clearly then is when an employee can be an agent. Hire and fire, or the ability to go out and enter into contracts with third parties on behalf of your employer. Either one of those factual situations creates a voluntary agency relationship, and accordingly, importantly, gives rise to these fiduciary duties. Fiduciary duties, which you must be familiar with for the exam, buzzwords alerts when we get that far. But yeah, you must be aware, because again, you must perform these fiduciary duties, and if you fail to do so, you could find yourself on the short end of a really nasty stick. Okay, all right. So make sure you understand that. As you can see from this next slide, agency is a fiduciary relationship. Okay, and remember, some of the key things here is that the agent shall act on behalf of and subject to the control of the principal, that is the employer, in dealing with third parties. Okay, and the real upshot is that you are given the ability to do what? Bind your employer to contracts, valid and enforceable contracts with third parties. Okay, just another informational slide. We've already discussed employer, employee, and independent contractor, I think, previously. This is where we are going to pick up here. And this is really the meats and bones of what you need to understand. We'll discuss the duties that you as the agent owe to your principal. That is the heightened duty that if you are an agent, you have the ability to hire, fire, or bind your employer to contracts with third parties, then you owe these duties to your employer, and you must be aware of them. Not just for my exam purposes, but also for your own self-survival. Okay, and relate to you a story. I occasionally get calls from folks that are managers, most often mid or lower level managers of some sort. They're clearly agents. They've clearly been entrusted with corporate property, and somehow or another they blow it. They breach one of these duties. The employer suffers a loss. They have insurance covering the loss, and the insurance company pays off. You know, the manager responsible loses their job, obviously. But believe me, you're not going to get any sympathy should the insurance company decide to recover that payment, that insurance payment they made for that loss that was your responsibility. They will have no compunction about suing you and trying to recover monies from you that they paid out on a loss. And so that's where I see this occasionally from managers. So you need to be aware of, don't just blow it off and think, oh, they don't care. It's a big corporation, they don't care. They may not care because they have insurance, but the insurance company, believe me, they will make an effort to collect if you are responsible for the loss. All right. So performance. Now, the first thing, this is kind of, we need to understand that this is this first one is performance, and it's a two-headed coin. There's two aspects of the performance duty that you must be aware of. Okay, and again, these duties extend not just to managers, but also to what members of the board of directors, officers, and key employees of the corporation. Okay, if you're an agent of the corporation, then you owe these duties. All right. Now, the first buzzword associated with performance is due diligence, and you see it. An agent must use reasonable skill and due diligence. Well, I want us to talk about due diligence first. Because this is the one I think where folks most often get themselves in trouble, is that if you agree as an agent to perform certain actions on behalf of your principal, then you must exercise due diligence in carrying out those duties. And this is almost a non-delegable duty, that if it is part of your job description as a manager to carry out certain tasks, you must actually carry out those tasks. You must make all reasonable efforts to carry out those tasks. And this is the one I think is gets folks in trouble most often. Because if you have problems with meeting deadlines, or if you are a procrastinator, or if you are having problems outside of the workplace, very often you will have agreed as part of your duties to conduct certain tasks and carry them out on behalf of your employer. Everybody understand that? Yeah. But because your child is sick, or because family vacations, or because you're in over your head a little bit and you're afraid to ask for help, whatever the reason may be, if you fail to attempt to make reasonable efforts to carry out those tasks, just blow it off, essentially, is what I'm talking about. And that's what I see most often, is that we let deadlines slide. We don't talk to people about those sliding deadlines. We don't get things done in a timely manner. Obviously, that's poor job performance. But if you blow deadlines for filing things that are doing things that have real consequences for your employer and can subject them to financial loss, guess what? You're going to be held responsible for that. And again, you need to understand, I think the most recent example I have of a manager being called to task for failure to properly secure inventory, which resulted in an employer's loss when he uh, failed to take some steps that he was required to do before he left for vacation. He knew it. He had been told. He had been trained. He didn't have time. Plane was leaving, and out the door he went. And of course, what happened? While he's on vacation, a loss appears in the inventory. Hello. Okay, everybody understand that? And the it's deemed to be a theft. They investigate it, but you know, things happen, things disappear. The company files an insurance claim. It was an insured loss. Insurance company pays off, and of course, not only does the fellow that fails to secure the inventory because he goes on vacation is going to lose his job, but also guess what? He got sued, right? And most likely ended up, if I'm not mistaken, I didn't take the case, but my understanding is he ended up having to make payment arrangements with the insurance company. And so be aware, you must take all reasonable steps to carry out the duties you have agreed to accept. And so you need to understand that there is no safe harbor for failure to exercise due diligence. I may say that again. There is no safe harbor for failure to exercise due diligence, to make the effort to attempt to carry out your duties. And the idea being is that if you should have the ability to understand and know that you are not performing adequately. And the idea being that if you find yourself in difficulties, what is the thing that you must do? And we're going to talk about this more. It's communicate. You must go up the chain or whoever you are reporting to and begin to ask for what? Help. Whoever imposed the deadlines on you, or that is whoever you're reporting to, you must begin to do what? Yeah, you can't hide things, and I think that's kind of the if you again, it's people skills, but if you think about it, you get yourself in trouble because man, I'm having problems with this, but I don't want to talk to anybody about it because it may reflect on my performance report, and I'm really wanting that raise or job. Everybody understand? Yeah. But believe me, the worst position you can find yourself in is thinking, I can take care of it, I'll get to it, blah, 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 and not begin to reach out in a reasonable amount of time before the deadlines or whatever's supposed to be done, and trying to get help to get it accomplished. Right? Everybody understand that? And so especially, and if deadlines pass and you blow it and you fail at that point to communicate, that is, tell on yourself, and any of those actions result in some financial loss to the company. And I think you can envision dozens and dozens of scenarios that you may find yourself in where that could happen. Guess what? Yeah, you may not just lose your job. It's a breach of a fiduciary duty. And again, due diligence is a non-delegable duty. If you have agreed to perform an action, you must make reasonable efforts to carry out that action. Okay. Now, the first prong being due diligence, and in all instances, you have to exercise due diligence, and that includes appropriate communication, keeping people in the loop as to if you're having difficulties performing. And of course, if you're supervising folks, you do have a little bit of a duty there too, to make sure that the folks performing under you are meeting those deadlines. And so, yeah, that can also be problematic if you have too loose a leash on the people you're supervising. Okay. All right. So due diligence, yeah. And then the next thing, if when you are exercising your due diligence, when you are taking steps to carry out the tasks you have agreed to do on behalf of your employer, then you must use reasonable skill in carrying out those tasks. And essentially, it's the skill that's expected of a manager of your knowledge, education, training, and skill. Okay, and so there's a standard here. It's a little bit of an objective standard, and of course it also we also assume the employer is going to give you appropriate training and education necessary. Some employers may expect you to come to the employer with all necessary skills and training, but that's seldom the case any longer, I think, especially at the managerial level, because we know you're going to need to be educated about policies, company policies, HR policies, things of all like that, and understand what responsibility you have in carrying that stuff out. Now, normally, then you must exercise when you are the level of care and standard that is required of a manager is going to be that ordinary care and caution as expected of a manager at your level. Okay. Now, one of the things that and sometimes this gets overlooked, there is a safe harbor here for managers, members of the board of directors, key employees, officers. It's called the business judgment rule. That says essentially that when you are making decisions as a manager, a member of the board of directors, a CEO or key employee, when you are making that decision, you've already, you're exercising your due diligence. You're taking steps to carry out your duties. You are using reasonable skill as expected in doing those actions and in making those judgments. But it is understood that the business is sometimes much more an art than it is a science, is that you can do due diligence, you can carry out, you can do the things necessary, you can investigate, discuss, research, do whatever you deem appropriate to be able to make a informed and rational decision as a manager, correct? Is that what you're supposed to do? Yes, obviously. But even though you've done all that, you've carried out those duties, sometimes for reasons that are not foreseeable, that are, as I said, this is more a business and making profit especially is sometimes more an art than it is a science. It's the understanding that managers and members of the board of directors and officers and key employees are not guaranteeing the success of any particular action. That's not required. And that's what the business judgment rule is about, is that if you take due diligence and make sure you understand that the prerequisite of the safe harbor of business judgment rule in all instances is that you actually do what? Do your due diligence. That you make a reasonable investigation, try to ascertain the relevant facts and conditions, maybe consult experts, people will discuss that know more about certain areas that you are wanting to do business with, tax people perhaps, marketing people, engineers maybe if you're looking at trying to convert a prototype into a saleable item. Do that appropriate investigation. Weigh the pros and cons. Do the appropriate evaluation to see whether or not the proposed action is going to be profitable or not, beneficial to the corporation, to the employer. Having gotten all that information, that is carrying out your due diligence, keeping everybody in the loop that's supposed to be in the loop, but communicating appropriately, and then making a recommendation or making a decision then based upon that due diligence investigation. And it is a rational decision that turns out to be unprofitable, then and only then can you claim the safe harbor of the business judgment rule. That is, if your employer suffers losses or the business or corporation suffers losses because of a decision you have made after reasonable investigation and using appropriate skill, then it turns out to be improvident, results in a loss instead of a gain, then you're not going to be held financially responsible for that loss. You will have the safe harbor of the business judgment rule. Now, however, make sure we understand, and we're going to go through this kind of take a factual situation and go through it step by step to kind of see how the outcomes go. But make sure you understand that before you can claim the safe harbor of the business judgment rule, that you must first carry out your due diligence. You don't do diligence. If you don't do your due diligence, that is, that you don't take reasonable steps to carry out the duties, you just blow it off. You don't have any safe harbor, right? Everybody understand that? You do not have a safe harbor. You are most likely going to be subject for that loss to some sort of claim. And you may end up actually being financially responsible for it in some part, okay? So that's important to understand. You're not a guarantor as a manager, a member of the board of directors, an officer, or key employee of an outcome of business, of proposition, right? Some action. However, before you can claim the safe harbor, that is, that you're not a guarantor of the outcome, you must first do what? Your due diligence. You must take those steps first. Blow it off, don't do the due diligence. Hello, you're most likely going to lose your position, your job, and you may be held financially responsible. All right. So that's the performance element, and it has two aspects: due diligence and reasonable skill. All right. Next slide. Onward. Notification. This is the communication thing, guys. And make sure you understand a couple of things. One, if a third party or an employee gives you notice, you are obligated to do what as an agent? Pass it up the chain. That if you fail to keep the people you are reporting to adequately informed as to all matters concerning the performance of your duties, guess what? That's a breach in and of itself. Okay. And also notice that if you you got to tell on yourself. Remember, we've had that discussion. This notification thing says if I'm missing deadlines, I'm falling behind, I got to keep people in the loop and enlist help, right? You got to do that under this duty, and also that if an employee or third party makes complaints or gives you some sort of important information, even if it's not particularly helpful to your personal career, that you have a duty to do what? Push it up the food chain. Okay, push it up the chain of command and make sure you do, because that breach in of itself, if it somehow leads to a loss by your employer, can lead to your personal responsibility for that loss. Loyalty. This is a big one, and you need to understand this one entirely. If you are an agent, you owe a duty of undivided loyalty to your principal. Hello, let me say that again. An agent owes the principal a duty of undivided loyalty. So you as a manager, a member of the board of directors, a CEO, or other key employee, if you're an agent of the corporation, guess what? You owe them an undivided duty of loyalty. That means that you cannot benefit yourself or third persons without the principal's knowledge and consent. Okay, and if you fail, suppose that you somehow come into some intellectual property that is clearly the property of your employer, but however you seek to use it for yourself or your brother-in-law, another family member, good friend, right? You pass that all along, and they attempt to use that proprietary information, that intellectual property, for themselves, or you use it for yourself. Is that a breach of that undivided loyalty? Yes, that property belongs solely to who? Your employer, right? And so um, that any situation like that requires full disclosure to the employer and their consent. And very often the reason why your incentive to give it secretly to another or yourself or use it yourself is often because you know that they're not going to consent to it. Also, you need to understand that any information acquired by the agent while carrying out their duties belongs to who? It belongs to the employer, considered confidential. I think we understand that. But make sure you understand this duty of undivided loyalty. And this means that you cannot use things like customer lists, and you see this occasionally where managers in a corporation will get together outside of work and say, hey, we can do this. These guys are idiots, the ones we're working for. Let's go out on our own and compete with these jerks. Well, you can find yourself in trouble real quick if you resign from your position as a manager and go out and start another business corporation with some fellow managers, or maybe even by yourself, and you begin to compete with your former employer. One, there may be non-competition agreements. I'm not really where that's going here, but most often what you see happen is that before that manager leaves, he will have been making plans to do this for quite a while, and will have laid the groundwork, and may well have absconded with or somehow otherwise use proprietary information, but belong to his employer, his or her employer, to start the new business. And if you begin to compete then with your former employer, you can very quickly find yourself the subject of a lawsuit wherein they want to know, well, where'd you get your customer list? Where'd you get your supplier list? And you can just kind of see this going on and on and on. And time after time, you may well find that information belongs to who? Yeah, your former employer. And so you could find yourself completely out of business. You could also find yourself owing any losses or profits, losses to your former employer, profits to you. Maybe they have to be compensated for, even if you didn't make any money do it. If they can show you use that information to cause them to lose business, Also, make sure you understand too, if you make any money doing something like that, that can be problematic. We're also going to discuss this idea of undivided loyalty with regard to directors and of corporations and officers, because very often with large corporations, the nationals, the multinationals, there's a limited pool of individuals that have the training, education, knowledge suitable to serve in positions as board members of the board of directors and CEOs. And the question we often see is, well, we seek sometimes when can a CEO serve as a member of the board of directors of another corporation, or when can an individual be a member of the board of directors of more than one corporation. Okay, and I remember that, and so you need to understand, it's like, well, you know, this duty of undivided loyalty can be problematic in those situations. And the idea being is that when CEOs and key employees and members of a board of directors of one corporation want to serve in positions like that in another corporation, generally you don't see, you know, two CEOs, but you will see a CEO or a CFO be a member of the board of directors of one corporation, another corporation than the one they're being employed as an officer or key employee. And you do see that happen, and the question becomes, well, how can that occur without a breach of this duty of undivided loyalty? And the idea being is that these individuals that hold these multiple positions cannot use the information that they've learned while serving as one corporation for the benefit of the second corporation, at least without the knowledge and acquiescence of that corporation. And it's difficult to do. We get into these things called Chinese walls, which basically means that you're supposed to somehow or another wall off in your own mind, and maybe even your files, what's discussed at one corporation and what you learn from one corporation and what's discussed at the other corporation. And so how can you do that? How can you accomplish that without breaching this duty of undivided loyalty? And it's real, and this is always the first inquiry, is that the two corporations that the individual is seeking to serve must not in any way, shape, or form be in competition. In other words, there is no conflict because they are engaged in entirely different lines of businesses. That's the clearest example, right? Everybody, you got that? If, you know, one is selling cars, and the other is in the media business somehow or another, owns radio stations and televisions and things like that. Generally, as long as there is full disclosure and they are not in direct competition, they don't own any subsidiaries or divisions that compete, then generally, if they are not in competition, then you're not going to see if there is some breach of what we call that Chinese wall. That is, for somehow or another, the decision maker in one corporation learned something, you know, the member board of directors, that he somehow uses in making a decision that is advantageous to the second corporation, then there's no conflict per se if they're not in competition, and of course there is full and complete disclosure. Remember, CEOs, CFOs, key employees, members of the board of directors, and managers owe this duty of notification. And so only if there is full and complete disclosure to both corporations and the board of directors and everybody is fully informed, then the idea being that if both corporations consent, then you can have these overlapping where one individual is actually serving in a fiduciary capacity with two different corporations. Okay, that can happen, and you do see that, but it can be problematic. Consider this scenario is that after everybody's agreed to the fiduciary serving in two different corporations, right, in a fiduciary capacity, after they both agreed, and we assume that there is no competition, correct? Then all of a sudden, one of the corporations acquires a subsidiary or let's call it a division, or maybe wants to start an entirely new business branch that will compete with the second corporation. So let's suppose that the car seller decides to acquire some media outlets that will compete directly with the communication company. And there is a proposal on the table to do that. What happens then? Can that individual that is serving in those overlapping fiduciary positions participate in that decision, and what must he or she do? And my position on that would be is that individual, upon that proposal being made, would have to resign from both corporations, quite frankly. And that could be problematic if you're a CFO or CEO serving on that, because it could require you to do what? Yeah, to resign that very lucrative position that you don't want to do. And that's the reason why you could see some folks not resigning from both positions. I think the duty of loyalty requires you to do that, and that to resign from both positions, because you just don't know. Let's suppose that you say, well, I'm just going to resign from the company that's proposing to go into this new business. However, you may have learned something before you resigned, prior to the proposal being made or simultaneously with the proposal being made. You have learned something. And you stay on at the other corporation, which is now going to be competing. If you're the CFO or the CEO, are you going to be tempted to tell that corporation that you have not resigned about the information you learned? And the answer to that is yes. Now you could argue, well, they agreed to it and they shouldn't, blah, 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 blah. Well, that's problematic. I think the clearer solution is to resign from both corporations if you hold these overlapping fiduciary duties. The idea being is that, well, when you accepted the second position, you should have understood that this type of scenario could arise, and that if you didn't want to subject yourself to having to resign from both positions, and I do think that you could find yourself in a lawsuit, right? The company you resign from could file suit saying that you must resign because you cannot use that information against us. You learned it as a fiduciary. You can. It's hard to understand. It's hard to see what could happen. You could see that, right? So make sure you understand that yeah, you can have these You can be a CFO, CEO, manager, and a member of a member of board of one corporation and serve as I think, as a member of the board of directors of another corporation. Uh, but you have to first understand that neither of those corporations in any way, shape, or form can be in competition, and there must be full disclosure, and they both must agree to that full disclosure. And in the event there arises subsequently to that, for whatever reason, a conflict of interest where they will become competitors in some way, then clearly I think the best course, the appropriate course, is to resign from both, although that may not happen. Certainly, you are going to be asked to resign from one, and so I think the best course, however, is both. Okay, because why? Because you could find yourself a subject of a lawsuit saying that what? You acquired this information, you owe, while serving in a fiduciary capacity with Corporation B, you cannot now use that to the benefit of Corporation A that you also are working for. You have resigned from us, but you also need to do what? Resign from them, because you cannot use that. And how can we be sure you're not going to use that unless you do what? Cut your ties. Okay, everybody understand that? Duty of undivided loyalty. Obedience. Let me make sure you understand about this one. As an agent, um, uh, as a manager, as an officer or key employee, you have an absolute duty to carry out all lawful, we understand lawful, right? You have no duty to carry out unlawful instructions of the principal in carrying out your duties. And in an artificial entity, um, you're going to ultimately, the authority, your instructions come from who? We know in the corporate structure it's from who? Not the shareholders. We already understand that, right? It's from the board of directors. And so when you get a lawful instruction from a quorum of the board of directors that have had a meeting and voted, adopted a resolution or something that's reflected in the corporate minutes that say that you shall do this as a fiduciary, then you must do what? Follow those instructions. If you disagree or don't like those lawful instructions, your obligation is to do what? Resign, quit. Say, I can't do this. I don't believe in it. I'm not qualified to do this. I don't think I can do this. Yeah, I think you have to take an affirmative action to certainly tell your supervisors and your employers, once you receive these instructions, that you cannot or will not do these for whatever reason. Remember, if you fail to do that, if you fail to follow lawful instruction, right, that is the result. You know, it's the due diligence things, really, I guess. And as a result, your employer suffers a loss because of your failure to follow all lawful instructions and do your due diligence, right? Then guess what? You could be held personally responsible. Not only get fired, but also do what? Be personally responsible for that loss. Accounting, this is a fairly simple and straightforward. Any property or money that comes into your possession as an agent belongs not to you, but to who? Principal. I think we understand the thing about inventory and monies and blah, 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 that those all belong to the principal. But remember, if we're an employee and we are developing, and we discussed this earlier in the case, there was that scenario, and the employer is providing us all the tools, and we are developing intellectual property such as customer lists and things like that. As an employee, as a manager, guess who that stuff belongs to? Not us, but who? Yeah, our employer, right? Make sure you understand that does include the intellectual property. the proprietary information that we develop as managers and members of the board of directors and CEOs and CFOs. That is included. And so we cannot use that information for the what? Benefit of ourselves or others without the principal's consent and knowledge. Okay? And very often, when you get in trouble is what? When you attempt to use that information without the employer's consent and knowledge. And whatever rules you seek to use to avoid discovery, believe me, you could find yourself the target of a criminal investigation and not just a civil investigation. So, because that is theft of property, right? Remember, understand that the property belongs to who? Your employer. And I'm not going to talk about the duties. The principal owes, your employer owes you certain duties, but it essentially boils down to do what? Yeah, paying you the money that they agreed to pay you as a result of your employment agreement. That's essentially what you get in return for these things we've been talking about, these 5 duties, right? Let's go over them real quick again. You should know and understand them for the exam. And of course, it is performance, right? Everybody understand that? Thou shalt use due diligence. That's number 1. And a reasonable amount of skill as expected of a manager at your level, knowledge, education, experience, right? And that you have a safe harbor. You as a manager or a member of the board of directors or officer is not a guarantor of outcomes. You are, however, must be able to claim the business judgment rule, that safe harbor. You must first do what? Use due diligence, make a reasonable investigation of the facts and circumstances, and then use reasonable, rational judgment in making the business decision. If you do that first, then you have the safe harbor if things don't go as you had hoped. Again, notification, communication up and down the chain, both ways, right? Have an absolute duty to do that. If you fail to do that, results in a loss, you're out of here. Loyalty, we understand that. Undivided loyalty to the corporation. If you're a manager, a member of the board of directors, a CEO, CFO, key employee. Obedience. You must follow all lawful instructions. Failure to do so can result in your termination and guess what? Possible financial responsibility for any losses. Accounting. You as manager, any and all intellectual property, I think, proprietary information that you develop as a manager or you come into possession with as a manager, director, key employee, officer of the corporation belongs to who? The corporation. And you cannot use that for anyone's benefit, yourselves or anyone else's, without the knowledge and acquiescence, permission of the corporation, of the employer. Okay? Okay, let me kind of see where we're at here, what I want to discuss next. All right, I want to discuss now, in light of the lecture, some hypotheticals, applications of the principles we just discussed to some factual situations, which, hello, you may see again in one form or another on the exam. The first one I want to discuss, the hypothetical can be found. It's in the Cheeseman on corporate governance. If you scroll down a bit, you'll see this blurb, and I apologize for the It's blurry, although this copy doesn't look too bad. I've got it blown up. Of Smith versus Van Gorkum. This is an interesting case about corporate takeover, but more importantly, what are the duties that are owed a corporation by their CEO, who's also chairman of the board, if I'm not mistaken, and a significant shareholder. Okay, now this is the facts. These are the facts here, just the facts. TransUnion, and this is not the TransUnion that deals with credit scores, I don't believe. I think this is a company that was engaged in the business of leasing rail cars, that many of the railroad cars, that almost all of the railroad cars, actually railroads don't own most of their rolling stock. It's actually leased from companies like TransUnion. But as you can see, it's a publicly traded holding company. It's Jerome Van Gorkum had been an officer for 24 years, CEO for 17, chairman of the board for 2. And he owns a big chunk of TransUnion shares. I think, as we are well aware, that generally executives will get some cash, but mainly the form of their compensation is from stock option plans. Generally, depending upon the particular stock option plan that the company has adopted, executives, directors of the company will often be given the opportunity to buy options now, to buy shares from the corporation at a certain price. For these options to be worth anything, they essentially have to exercise the options low and then sell high. That is, let's suppose that the option says that they have to pay $10 a share to exercise the options. To be able to have any value, those shares must be above what? A certain price, $10, right? And so what you would see executives very often doing then is buying the shares at 10 and then waiting for the stock price to rise above 10. And maybe even when they exercise them, it's already above 10. They have a built-in profit, but then they sell high, say $30 a share. They've just made $20 a share. A profit, right? Okay, and so that's kind of my guess is that over the years, Van Gorkum has been rewarded with stock options that he has exercised, and he now has, a big chunk. However, for whatever reason, sorry. For whatever reason, the indication here is that there was a mandatory retirement age. But for whatever reason, Van Gorkum wanted to cash out his 75,000 shares. Now, the problem most likely Van Gorkum faced was the corporation most likely did not have enough cash to do what? To buy back his 75,000 shares. And he knew if he went onto the market, it's a publicly traded company, and began dumping these 75,000 shares, what's going to happen to the value of those shares, right? It's probably going to go down. And so he believed the way to best maximize the price per share that he could get for his 75,000 shares was to try to sell TransUnion to a third party. And the third party that Gorkum found was Jay Pritzker. That may seem sound familiar to you. It should. Jay Pritzker is the father of J.B. Pritzker, the current governor of Illinois, or the governor-elect, I guess. I have actually met the Pritzker family on a couple occasions. They have a compound, and when I say compound, I mean compound, up in Lake Geneva, Wisconsin. In the mid-2000s, I was working for an attorney, a successful law firm, I guess I should say, up in Northern Illinois, and they had the principal partner had wasn't a compound, but he had a small home on Lake Geneva also. And on a couple different occasions, I had the opportunity to attend political fundraisers for different individuals from the Chicago area at the Pritzker compound. And it's quite a place. But the Pritzkers made their money, the family, by organizing what we call a private equity firm. And what they would do would be to take publicly traded corporations and for various reasons then take them private. In other words, the private equity firm would make an offer to buy all the outstanding shares of a corporation at a certain price. And then if that agreement, if that offer was accepted by the board of directors of the corporation and a majority vote of the shareholders, then the Pritzker private equity firm then would make that purchase, and then they would have essentially the holding company would be the sole shareholder of the corporation that they had taken private. And generally now, let's make sure we understand, do they still have to have board of directors meetings and comply with the corporate form of business? Yes. And there's various reasons why they could do that. But generally, the idea being is that the value of the corporation itself it can be acquired is greater than the price they would have to pay to buy all the shares of the outstanding stock. The Hyatt, if I'm not mistaken, Hyatt hotel chain is another example of what was once a publicly traded company that the Pritzker private equity firm took private. But here we have this example. Now, Pritzker and Van Gorkum enter into negotiations for that sale of all the outstanding shares of TransUnion to Pritzker. They come up with an agreement of $55 per share. At the time of the agreement was made, if I'm not mistaken, I believe the shares were trading in the open market at 38. So Pritzker has agreed to pay a premium of $17 a share. Sounds like a pretty good deal, and it's cash on the barrelhead, it sounds like. Van Gorkum would profit, I'm sure, quite nicely at $55 per share. Now, Van Gorkum, the corporate act in Delaware would have required this proposal be brought to the board of directors. And of course, Van Gorkum did that. He called a special meeting of the board of directors. Let me find that. And presented the proposal to the board of directors. And essentially said, here, we've reached an agreement Pritzker's going to pay us $55 a share for all our outstanding stock. There was apparently some dissent among some of the members of the board of directors. They were concerned whether or not there could be another suitor that could possibly be interested in competing, try to get a bidding war going on with Pritzker for the price, try to see if there would be other potential buyers. And also, what about a valuation study? And this can be done, this is done routinely. Let's have a third party take a look at what the fair market value is of the true fair market value, not the book value, not the value indicated perhaps in the financial statements, but the fair market value of the assets of the corporation and what the true liabilities are, and see what the valuation is and see how that compares per share for the $55. But that wasn't done, was it? Now, my guess is Pritzker was saying, take it or leave it. If you don't, you have a certain amount of time to accept and consummate the agreement. And if you don't, deal's off. And so the board of directors voted to accept the deal. And essentially then recommended that the merger, that is the buyout, occur. And one of the things that shareholders have, they get to vote for one of the rights that shareholders has, and this talks about it. In addition to voting for a board of directors, is to vote on mergers, sale of assets, things of that nature. Shareholders do get to vote and approve of. Here the board of directors recommended it. And presented it to the shareholders for a vote. Interestingly, it is pointed out that two of the TransUnion board of directors actually affirmatively attempted to dissuade possible white knights, that is other suitors, other potential buyers, in making an offer for the company, investigating it. Again, I'm not quite sure why, but everybody was, shall we say, hot to trot to consummate this deal. The proposal was presented to the members, the shareholders. They voted in favor by 69.9%. And the merger was consummated. Now, the minority shareholders, the shareholders that voted against the proposal, I guess it'd be 30.1%, if I could do the math. Those shareholders, those minority shareholders, actually then ended up suing Van Gorkum and the other members of the board of directors. Okay? All right, and what argument did, what do you think? What argument do you think those minority shareholders made in attempting to hold Van Gorkum liable? Now, of course, the argument Van Gorkum is going to make is, look, hey, the share price was 38. We sold it for 55. There's a built-in guarantee of profit of $17 a share. What's the gripe? Well, the gripe is this, that Van Gorkum and the other members of the board of directors did not perform their due diligence. They did not adequately investigate the proposal to ensure that that was indeed the best price they could get for each share of stock. They just kind of did what? Saw, Van Gorkum walks in, says, this is a great deal. We got to do this. We got to do it right now. Let's go. And they didn't do their due diligence, right? They did, okay, let's go. And thought that on its face, it was fair. Two particular steps the board should have taken immediately. One was to solicit other potential buyers. And in fact, the facts, I guess, at trial showed probably that there were some folks that were interested. But did the board of directors investigate that potential to see if they could get more than $55 a share? No, they didn't. Okay, no, they didn't. And at the very least, they should have done what? Had a valuation study done. And that, again, and that's what, believe me, Pritzker would have had an evaluation study done before he would have ever made an offer to Van Gorkum. And believe me, what do you think? Do you think Pritzker's valuation study would have shown that TransUnion was worth more than $55 a share? I think so. And I think if the directors would have commissioned such a study on their own, that also would have shown that the value was above $55 a share. And so failing to investigate the possibility of other suitors that would have been willing to maybe bid more, and failing to actually appraise yourself what the true fair market value of TransUnion was. Those are breaches of due diligence. They failed to carry out their duty to adequately inform themselves before making the decision. Okay? And again, they don't get the safe harbor. They do not get the safe harbor of the business judgment rule. Everybody understand that? This is not a case of being fully informed and then making a rational business judgment based upon those being fully informed, right? If anything, this kind of showed to me that this was willful blindness almost, that they were sacrificing the price for expediency of just a few of the shareholders. And what the court said was that is their failure to exercise due diligence essentially equated to gross negligence, and that a trial would determine whether or not a jury actually $55 per share price was fair. And so you would essentially then present to a judge and jury the testimony of your valuation expert if you're the minority shareholders. And if that shows that the fair market value was $65 a share, then the minority shareholders then would be entitled to that additional $10 from the directors and Van Gorkum per share. Everybody, I mean, yeah. So that's kind of, that's failure to exercise due diligence here was what these folks did. One other point I want to make about this case, these minority shareholder cases, these are known as what is known as derivative suits. And that's really why Delaware is a state where many businesses incorporate, because they really do restrict to a great extent these thing called shareholders derivative suits. Now, essentially, what's going on here is that these suits are not brought in the name of the shareholders, although they're the ones suffering damage. They are actually brought in the name of the corporation, because who did Van Gorkum and the other directors owe their duty to? It wasn't to the shareholders directly, it's to who? The corporation. And what shareholders derivative suits recognize is the idea that, well, when you have the officers and board of directors conspiring together to breach the duties to the corporation, there's nobody left to vindicate the corporation, right? Other than who? The shareholders, and generally the minority shareholders. So the law recognizes, when all the bad guys are the officers and directors of the corporation and they are breaching their duties to a corporation, then in that instance only, may a shareholder bring direct suit. And it's not direct, it's derivative. But what they are doing is they are seeking to enforce the right of the corporation to have these duties fulfilled. And the corporation is the one that suffered a loss, although it trickles down to the shareholders. But it's the corporation that suffers the loss. And they bring the suit in the name of the corporation, since it is the board of directors and the officers that are engaging in the breach. That's a shareholders derivative suit. Okay, I think there's one other hypothetical I want to discuss here, and then maybe I think you have everything you need to do the discussion questions. And this is the one about the widget. And you're, let's say you're a member of a board of directors, and you are presented by one of the officers, just say CEO, with a proposal to manufacture, market, and sell a widget, a new kind of widget. And the CEO comes in with some sort of vague proposal, and without a whole lot of documentation, saying it'll be a great idea, let's do this. And kind of like Van Gorkum's board, just following the recommendation without doing any sort of due diligence, give the green flag to this idea, to the CEO, to go all guns forward with the production and marketing and sale of this new widget, which the CEO does. Makes periodic reports, which are kind of sort of informational. Maybe even include some numbers about what's going on with regard to costs of development and things like that. Eventually, the widget prototypes developed, board says, yeah, it looks great. Put it in production, and they do. And then they put it on the market, and after incurring, let's just say, $100 million in costs, yeah, all right. the thing becomes one of the biggest flops since, I don't know, whatever, right? Um, and you end up with a gazillion of these things sitting in a warehouse, um, and they go nowhere. And so you have just now, the corporation has just now incurred $100 million loss. Stock price goes through the tanks. Shareholders are up in arms. I'm very unhappy with the outcome of this, obviously. Now, what do you think? If you're a shareholder, can you have a remedy, perhaps as a shareholder's derivative suit, seeking to hold members of the board of directors and the CEO responsible for those losses? Is there a theory, we've discussed it already, of course, that could be put forward that maybe the CEO and the board of directors breached some of these duties they owed the corporation before embarking on this project that resulted in $100 million in losses for the corporation? And the answer to that, of course, is yes. Because as soon as the proposal is brought by the CEO to the board of directors, what should the board of directors, what is required by the board of directors to meet their due diligence obligation? Remember, they have that, right? They have that. They have the duty to investigate and inform themselves to the greatest extent possible about whether the proposal being put forward before them is going to be profitable, feasible. And there's all sorts of things that need to be done before a decision of that magnitude can be undertaken. And guess what? If they don't do that due diligence, that investigation to determine or demand that they be presented with studies and information that would be needed to determine whether or not such a project would ultimately be profitable. And you got to think globally with this, folks. And so think about it a little bit. Think about, well, you have to have revenue, and then you deduct expenses from that revenue, and that gives you what? Profit. And so do you need to investigate, if you're wanting to undertake a project like this, both elements of that equation, both revenue side and the expense side? Sure. So let's talk about that. Think about this. I mean, I think you study this stuff in little bits, but sometimes we don't understand the importance of this stuff globally. First of all, first thing, if a CEO says, here's a widget, an idea for a new widget, let's make it. The first thing I want to know is, okay, is there a market? Now, he said it's new. Is there a market for this new widget? And are there things we can undertake to do, direct others to do, so we can ascertain that? Sure, we do. I mean, that's what marketing people do, right? They go out and try to ascertain, is there demand for this new widget? Do people want it? Would they use it? More importantly, would they buy it? Yeah, is there a demand? Yes. Obviously, if a marketing study tells us there is no demand for this new widget, and people think it's just, it's nothing I want to buy, then obviously we shouldn't really go forward. Now, there may be some exception to that. So I think that marketing people tell you, well, we can create demand with advertising and different marketing strategies. Well, you have to be careful about that, because ultimately the consumers just tell you, no, I don't want it. And if the studies show there's a high likelihood and probability that it's just not something that there's a current market for, it doesn't mean it may not be in the future, but just right now, no. We have to take that into account, don't we? The other issue too is, okay, there may be a demand, but demand at what price? I think we will find that, yeah, I would like to have that if you give it to me. If they're free. But we have to understand too that very often the price demand curves, right? It's that demand will very often go down and shrink as the price goes up. And so we need to kind of understand that we may be able to sell X number of them at one price, but a far less number of them at another price. And that can get us then into the other side of the equation. Well, we know there's a demand, and that, we kind of know what the price demand curve looks a little bit like from our marketing studies, kind of trying to get a handle on that a little bit. So the next thing is okay, can we produce this? Is it feasible? And so do we need to do engineering and production studies on that? Yeah, obviously. Can we produce it here? Or can we find contractors, people we can farm out production to? What's that going to cost us? Do we want to do it ourselves? Based upon our price demand curve, how many units do you anticipate we initially want to produce? And how much? How much is it going to cost us to produce the item? And then once we have kind of gotten a handle on those issues, and this applies to both goods and services, folks, frankly, this approach, this rational approach to decision making, that then you kind of get a handle a little bit. Well, can I make money doing this? Can I make a profit doing this, or can I not? Because you got your price demand curve, you know what that is. And if you've learned to come to find out that production costs and development costs of actually doing this widget, producing the prototype, and then taking the prototype and putting it in production, if those costs are greater than the price that your marketing studies show a consumer would be willing to pay for those goods or services, yeah, you're gonna end up doing what? Losing money. And it's only if those studies reveal to you that there is indeed a projected demand at a certain price that is above the cost of development and production, can you make a rational and reasonable, educated assumption that this project could well be what? Profitable. That's the rational decision-making process that business people, members of the board of directors, should go through in evaluating a proposal, either large scale or small scale. And as members of the board of directors, and actually as executives, we have the right and ability to rely upon experts that we hire to develop and present us with this information. And our due diligence requires us to make this investigation, either as the officer, should the CEO probably have already started this process and brought this information to the board to begin with. If the CEO doesn't, does the board have a duty of due diligence to require the officers to go back and do their homework before making a decision on the proposal? Sure, that's the lesson of Smith versus Van Gorkum. Right? Everybody understand that? And yes. And so let's make sure we understand kind of the scenarios. Let's game this out, so to speak. Let's suppose that the board, the CEO is all enthusiastic for the project, that the board does commission some of the studies. Let's say some of the studies, let's do the easiest thing. All the studies indicate that there is a demand, that the price that the marketing study indicates consumers would be willing to pay is substantially above the cost of development and production as it's projected currently when we make the decision. Yeah, that means it should be profitable. And we all vote, all the board of directors votes to, based upon a review of that information, to go forward with the project. They monitor the project, the board of directors and the CEO monitor the development. Things seem to be going okay. When the project finally gets to the stage of sale, I'm sorry, it doesn't happen, right? They still end up with a warehouse full of the product. In that case, does the board of directors and the CEO get the safe harbor of the business judgment rule? The answer to that's yes. They did their due diligence. They did the investigation. They applied a rational process to the decision making, and they went forward with it. Turns out it was not a good business judgment. They lost $100 million. Hello. However, are they safe from shareholder derivative suits? Should be, yes. Because why? They did their due diligence. The due diligence they did indicated that it should be a profitable undertaking, but it wasn't. Again, more art than it is science sometimes, right? Yeah, okay. So they do get, in that instance, the benefit of the business judgment rule, that safe harbor from being shielded from the losses. However, let's look at the other possible scenarios then, is that they didn't do their investigation. They were like the board of directors of TransUnions, and they blindly followed the CFO, and it became a cropper, and they lost $100 million. Could the directors then be, and the CFO then be liable for failing to do their due diligence? And so that's yes. Okay. One other possible outcome, and you need to consider this, and this really gets into the gross negligence, and we'll tie this into Buffalo Creek a little bit. Let's say that the board of directors does the studies. And the board of directors, all the studies, they don't just come back, maybe it's an iffy proposition, and that's a gray area, quite frankly, but that it's a guarantee, there's no demand, that production costs are going to be problematic, quality control is going to be problematic, cost, I mean, that you're going to have to ask so much per unit that consumers have no interest in it. But because of the persuasion of for whatever reason, of the executives that are pushing the project, the board agrees to do it anyway. That despite the studies that show that in all likelihood this is going to be a loser, but a big loser, but we go forward with the process anyway and the project. And indeed, as the studies predicted, it's a big loser, right? Do you get the protection of the business judgment rule. You did your due diligence, but what did you ignore what the due diligence was telling you? Yes, that's recklessness, right? Everybody understand that? That's recklessness. That when your due diligence tells you this is a bad idea, don't do this, and for whatever reason, you proceed anyway, then that's gross negligence, recklessness, and you do not get the safe harbor of the business judgment rule, right? Everybody understand that? That when you act willfully and blindly in light of all the facts and circumstances, you are not acting rationally, right? You're not acting rationally. And when all the experts, I know. Well, what about this story or that story about the entrepreneur that succeeded in the face of all obstacles? That's a rare occurrence, right? We understand that. And yeah, if you succeed, great for you, right? If the board agrees in the face of what all the experts are telling them to go forward with it, and you're successful, yeah, good for you. You get all the glory. But guess what? It's a big risk. And most often, are the experts going to be right? Yeah, they're not always right, but the idea is that when you use good information, and that you understand that it's good information, you've done the studies correctly, and you ignore all the red flags, then you're acting recklessly. And in that instance too, you're not entitled to the protections of the safe harbor rule. And as we'll see in Buffalo Creek, I'll bring this back to when I will finish talking about Buffalo Creek then when I do my online lecture later in the week on Tuesday, right? Yeah. And that'll be the last one. Then I'll bring that back because the argument that saves Stern in the end for 2/3 of his clients is the argument that Pittston executives and the Buffalo Creek executives acted recklessly. Recklessly. That's above mere negligence, failure to exercise ordinary caution. And again, when you act recklessly, you don't get any safe harbors. And we'll see that indeed became true for Buffalo Creek, as our executives, our board of directors, if they act recklessly in ignoring the advice of the experts that they've commissioned to study particular issues. Okay. And that could be your lawyers and accountants too, folks. Hello. Okay. And so with that, I think I have completed, I've said everything I want to say about this particular part of the discussion questions. And I think you should all then have enough material then here to be able to complete the discussion questions, and with a little bit of work and study, do quite well on this last exam. Now remember, this last exam will be up from this next coming Wednesday morning until Sunday night. I will discuss that more at the next lecture online section. And it will cover the material on forms of business and choice of entity that we discussed, the material we just discussed today on agency and corporate governance and fiduciary duties and understanding those. And then also the third area this last exam will include Buffalo Creek questions, which you should be working on with your discussion questions with the assignments 2, 3, and 4. And with that, I'm going to sign off.